Half a decade has now passed since one Supreme Court decision didn't merely alter a single state's concealed carry licensing scheme. It triggered a legal domino effect that continues actively remolding firearm regulations in courtrooms nationwide as we speak in 2026. If you've noticed that Second Amendment headlines have been non-stop for the past few years, ruling following ruling, some broadening protections, some narrowing them, some overturned on appeal, every single one of them can be traced to a solitary 2022 opinion known as New York State Rifle and Pistol Association v. Bruen. The bulk of media reporting on any particular firearms decision frames it as an isolated incident, one lawsuit yielding one result. But the truth is, practically none of these judgments stand alone. Each is a direct offshoot of the same analytical framework the justices put in place during the summer of 2022. I'm going to guide you through precisely what has unfolded since that opinion was handed down, jurisdiction by jurisdiction, lawsuit by lawsuit, so you grasp not merely what Bruen held, but the complete cascade of repercussions it unleashed, all the way through to the decisions that dropped only a few months ago. Before we dive into the chronology, if your goal is to genuinely track how a single high court case reconfigures an entire legal field across multiple years, rather than merely catching disconnected headlines without the narrative thread linking them, hit subscribe and enable alerts immediately. Bruen represents the clearest modern illustration of how a single judgment's consequences keep rippling outward for years, and comprehending that full chain is essential if you want to anticipate where this legal terrain moves next, instead of being caught off guard by each new development as it surfaces. Let's examine precisely what has occurred since the summer of 2022. Here is the single-sentence summary of Bruen's holding before we trace everything that grew from it. During June 2022, the Supreme Court held that Second Amendment disputes must be resolved through historical analysis exclusively, meaning the state can defend a contemporary firearms statute only by identifying a sufficiently analogous historical regulation from the founding period or the Reconstruction era, rather than by contending the statute addresses a pressing present-day public safety concern. That one methodological pivot set everything in motion because it meant that literally every firearms statute on the books across the entire nation, thousands of laws spanning all 50 states plus the federal government, suddenly needed to be reassessed under an entirely different constitutional standard than the one that had controlled for the prior 15 years. The opening chapter of this timeline covers the immediate fallout, the weeks and months directly following the opinion's release. Jurisdictions operating discretionary may issue licensing regimes comparable to New York's original statute. Among them, California, Hawaii, Maryland, Massachusetts, and New Jersey were compelled to react almost instantly because their existing structures were squarely incompatible with Bruen's requirements. Certain states transitioned to shall-issue systems fairly rapidly, embracing objective, uniform licensing criteria instead of the subjective proper cause standard Bruen invalidated, following the pathway Justice Kavanaugh's concurrence had more or less sketched out. Criminal background screenings, training mandates, and comparable neutral prerequisites that any eligible petitioner could fulfill. Other jurisdictions, New York prominently included, pursued an alternative path, enacting new statutes that preserved licensing requirements, while massively enlarging the catalog of sensitive locations where carrying stayed forbidden even with a valid license, wagering that limiting where a license remained operative would produce comparable practical outcomes to the old discretionary framework, without encountering the precise legal defect Bruen had identified. The second chapter covers the surge of permitless carry bills that gained substantial momentum in the years after Bruen, including in states that weren't directly compelled to modify anything by the ruling on its own terms. As of 2026, 29 states now permit residents to bear a concealed handgun without obtaining any license whatsoever, a movement occasionally labeled constitutional carry that predated Bruen, but grew considerably in its wake. As legislative bodies in firearm-friendly states leveraged the opinion's rhetoric and logic as political and jurisprudential fuel to abolish licensing requirements completely for individuals who are otherwise lawfully permitted to own a gun. The majority of these states continue to maintain an optional licensing procedure, which retains genuine utility primarily for reciprocity purposes when journeying to other states that honor licenses but don't grant equivalent recognition to permitless carry standing alone. Meaning a resident of a permitless carry state who wishes to remain armed while visiting elsewhere frequently still has strong incentive to secure the optional license, despite it no longer being legally mandatory in their home state. The particular age floor for permitless carry differs by jurisdiction, with some fixing the minimum at 21 and others permitting it at 18, reflecting ongoing independent legal battles concerning age-based firearm limitations that Bruen's historical framework has likewise been deployed to in the intervening years. The third chapter is the sensitive places struggle, which emerged as among the most intensely litigated and truly disputed domains of firearms law in the period directly after Bruen. The Bruen majority itself recognized that particular sensitive sites, schools, government facilities, and legislative assemblies among the illustrations the justices offered have traditionally been subject to carry prohibitions and remain constitutionally valid to regulate even beneath the new historical test. Multiple states reacted to Bruen's central holding on licensing by dramatically broadening their own definitions of what qualifies as a sensitive place. In certain instances, attempting to classify such an expansive slice of public and private territory as sensitive mass transit, public parks, entertainment facilities, banks, that critics contended the practical impact effectively rebuilt the same restrictive carry climate Bruen had just dismantled, merely through an alternative legal channel. New York's post-Bruen legislative countermeasure became one of the most intensely scrutinized illustrations of this approach, extending sensitive place prohibitions to encompass an exceptionally wide array of locations while simultaneously subjecting Manhattan and other heavily populated urban zones to a default assumption that commercial establishments banned carry unless they affirmatively posted permission otherwise. An approach that mirrored, and in certain respects foreshadowed, the precise variety of private property default rule the Supreme Court would ultimately invalidate in Hawaii's case years afterward. This strategy spawned considerable litigation on its own, with tribunals across the country arriving at divergent conclusions regarding precisely how far a state's sensitive places classification could expand, before it crossed from a legitimate historical carve-out into an unconstitutional circumvention of the ruling's central holding. A battle that in numerous respects previewed the exact species of state versus court tug-of-war that would characterize this entire field for years to come. The fourth chapter is the point at which the Supreme Court itself was forced to re-enter the fray to clarify its own test, because the inconsistency Justice Breyer's dissent had warned about proved to be a genuine, significant problem within merely 2 years. In 2024, in a case titled United States v. Rahimi concerning a federal statute disarming individuals subject to domestic violence protective orders, the Supreme Court ruled 8-1 that the government need not locate a historical twin, an identical statute from centuries past, merely a historical analog that is relevantly similar in both the rationale for burdening the right and the magnitude of that burden. This clarification became necessary because lower tribunals had fractured dramatically over how stringent the historical analog requirement truly was, with some courts invalidating laws that appeared obviously sensible, including the domestic violence protective order statute at stake in Rahimi itself, solely because no sufficiently identical historical twin could be identified from the founding era, an outcome that struck numerous observers as a disturbing, nearly absurd consequence of interpreting Bruen's language with excessive literalness. The fifth chapter is the summer of 2026, when two significant opinions arrived within 7 days of each other and demonstrated precisely how far Bruen's reasoning keeps extending into truly distinct spheres of firearms policy. On June 18, 2026, in United States v. Rahimi, the Supreme Court ruled unanimously that a federal statute banning gun possession by unlawful drug users could not be enforced against a Texas man based purely on his acknowledgement of routine marijuana consumption, absent any supplementary proof of impairment or dangerousness. Applying the identical historical analog framework Bruen fashioned to conclude, the government's comparison to antiquated habitual drunkard statutes failed because those historical measures targeted individuals who were effectively incapacitated, not merely individuals who consumed a substance on a regular basis. 1 week later, on June 25, 2026, in Wolford v. Lopez, the court ruled 6-3 that Hawaii's statute requiring concealed carry licensees to secure explicit authorization before carrying onto private property opened open to the public violated the Second Amendment. Once more, applying Bruen's historical framework to determine Hawaii's proposed historical analogs, including a statute connected to Louisiana's Black Code, weren't relevantly similar enough to sustain the modern restriction. Legal academics monitoring both opinions observed they landed within days of each other, and both drew directly upon Bruen's core methodology. One employed to safeguard gun ownership rights for drug users, the other to safeguard carry rights on private property, demonstrating the same historical framework keeps yielding major headline-producing outcomes in genuinely separate corners of firearms policy 4 full years after the original opinion. One constitutional law scholar, who closely monitors the court's Second Amendment docket, characterized the pattern emerging from these two opinions as proof of a court displaying what he termed extreme skepticism toward firearms regulations of every variety, particularly newer ones enacted specifically in reaction to Bruen itself, a dynamic that renders it extraordinarily challenging for state and federal lawmakers to draft firearms statutes that can actually withstand this now years-old, yet still developing historical examination. The 6th chapter covers what remains actively winding through the courts at this moment, because Bruen's aftershocks haven't ceased, and multiple major questions remain truly open. Legal challenges to federal prohibitions on gun possession by individuals convicted of nonviolent felonies have kept arriving at the Supreme Court. And as recently as early 2026, the court declined review in a sizable cluster of these cases, including petitions from individuals arguing their specific nonviolent felony convictions shouldn't permanently bar them from gun ownership under Bruen's historical framework, leaving the foundational legal question open for the time being while several additional comparable petitions remain pending before the justices. Separately, litigation concerning age-based restrictions, specifically federal and state rules mandating that a purchaser be 21 to acquire a handgun, has generated conflicting outcomes in different federal circuits, with at least one major appellate court, the 5th Circuit, holding that federal law barring handgun sales to 18 to 20-year-olds is unconstitutional under Bruen, reasoning that the Second Amendment's text encompasses these younger adults within the class of persons whose right to keep and bear arms is shielded, and specifically observing they were historically included among the population enrolled in militias the amendment was drafted to protect. While other courts have reached contrary conclusions on comparable facts, precisely the species of circuit division that customarily signals the Supreme Court will eventually need to intervene and resolve the conflict nationally. The Supreme Court has likewise declined to hear certain age restriction cases as recently as this past summer, meaning this specific issue remains unsettled and inconsistent, depending entirely on which region of the country one happens to reside in, with some states and circuits presently permitting 18 to 20-year-olds to purchase handguns under this reasoning, while federal law in other jurisdictions continues enforcing the conventional age 21 threshold. The 7th chapter addresses what all of this truly signifies if you're attempting to comprehend your own rights today, in 2026, rather than trying to follow every individual ruling as it emerges. The single most critical insight is that Bruen didn't generate one neat, definitive, nationwide resolution to firearms rights questions. It produced an ongoing, actively developing legal process that keeps spawning new opinions, new circuit divisions, and new Supreme Court interventions on a continuous basis, 4 years along, and still substantially unresolved on multiple major fronts. If you possess a firearm, carry routinely, or are merely attempting to understand the legal landscape in your own jurisdiction, treating your present understanding of the law as something requiring periodic refreshment, rather than a static, permanently fixed body of knowledge, is truly the most accurate manner to approach this entire domain, given how much has kept shifting since 2022, and how much obviously remains in flux at this very moment. Let's pull back and identify the single strand running through every development surveyed in this timeline. Bruen didn't merely resolve a lawsuit, it invented an entirely new methodology, a requirement for historical analogs in place of modern policy weighing, and that methodology has been applied, tested, refined, and contested continuously across the 4 years since, touching spheres of firearms policy that appear wholly unrelated on the surface: licensing systems, domestic violence restrictions, drug use, private property carry rules, felony disqualifications, age limitations, all linked by the same foundational legal question the justices answered during the summer of 2022. Each of those individual opinions, whatever precise result it reached, is genuinely just another installment in the same continuing narrative that began with two men in New York being refused concealed carry licenses because they couldn't articulate a sufficiently particularized reason for seeking one. It's worth recognizing precisely how extraordinary this degree of sustained legal activity truly is, even measured against the benchmark of major constitutional rulings. Most landmark Supreme Court decisions stabilize a legal field for a meaningful interval, furnishing lower courts and legislatures with a steady framework to operate within for years before the next significant case compels reassessment. Bruen has operated differently, generating an almost uninterrupted flow of subsequent litigation, circuit splits, and Supreme Court interventions at a tempo that has genuinely astonished even seasoned court watchers. Some of this stems from the sheer magnitude of what Bruen actually accomplished, supplanting an entire methodology rather than deciding one narrow issue, which meant nearly every existing firearms statute in the country suddenly required fresh litigation to ascertain whether it could survive beneath the new test. Some of it stems from the genuine difficulty of the historical analog inquiry itself, an analysis that, as Justice Breyer's dissent predicted, simply doesn't yield clean, predictable, uniform answers the way a more conventional balancing test would have, meaning nearly every novel fact pattern creates fresh uncertainty rather than a direct application of settled precedent. If you retain one thing from this analysis, let it be this. When you encounter a new firearms rights ruling in the news, whether it expands protections or contracts them, the real story is rarely confined to that single case. It is almost invariably the latest installment in the narrative that began with Bruen, applying the same historical methodology to a fresh set of facts. Grasping that connecting strand is what distinguishes genuinely following this legal field from merely reacting to isolated headlines as they randomly appear. 4 years in, with major questions still open on nonviolent felon disqualifications, age restrictions, and likely several additional categories of firearms regulations still advancing toward the Supreme Court, this narrative is nowhere near concluded, and comprehending the framework Bruen established is the only dependable method for making sense of whatever arrives next. If this assisted you in understanding the full arc connecting 4 years of firearms rights headlines back to a single foundational case, share it with someone who has been attempting to keep pace with all of it without ever seeing how the pieces connect. Subscribe so you catch the next chapter in this continuing story the instant it unfolds, and I'll see you in the next